Broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, folks, and welcome to today's Mailer's Hub webinar. Today we're going to be covering the California Consumer Privacy Act, or CCPA, one of those little things that's going to sneak up on many of us as time passes here. So it's very important for us to all understand the impact it's going to have on our businesses, on what we need to do in our business processes, and to be prepared to meet various compliance requirements. Speaking today are Chuck Price and Leslie Price. Chuck is a principal consultant at Axiom's Omnichannel Strategy Group. In his role, he helps organizations collect, position, and leverage their data ethically. Privacy, of course, is a critical part of any data strategy. So as part of his practice, Chuck's team supports CCPA assessments and provides consulting services to move client compliance forward. Today, Chuck will give you an overview of CCPA, point to a few key considerations of the law, and answer any questions that you may have. On your screen there, you can see a place to enter questions. So as we go along today, please feel free to type in those questions, and we'll get those answered in good time. Today's session is being recorded, and the recording will be available for subscribers, as always, after we're finished. So without any further ado, Chuck, you're the man in charge. Take it over.
All right, thank you. Okay, please do forward questions as you have them. Be happy to save some time at the end for a Q&A session. So sometimes that's where most of the value comes, and that's available to you. Please make use of it. This California CCPA, I'm just going to jump right in, is the first of the major laws that's caught everybody's attention, but it's not the start of privacy in the United States. Axiom was the first company to create the role of Chief Privacy Officer. We do 500 plus assessments a year, many audits. As you can imagine, the kind of data we have available, privacy has been a focus for us a long time. We do one-hour teleconferences, we do workshops, we do multi-week engagements to help you move your compliance forward. And CCPA, as I said, is the start of it, but regardless of your market, some of you on the call may not have or conduct business in California, may have other geographies of interest, but California started the ball rolling with CCPA. A lot of other states are in various stages of considering privacy law. So you can see a number of them listed here for you. It's still valuable, should you be in some other state, to learn a little bit about what California has done. And the reason for that is there's a lot of borrowing going on in terms of privacy law. California borrowed a bit from GDPR, which is the European Union's privacy legislation. And other states are borrowing heavily from California directly, or are also borrowing from GDPR. So expect to see other states do similar things to California. So even if your geography is different, I hope that by going through the CCPA today, you'll find something valuable to your own market. So what is CCPA? CCPA is a privacy law passed back in June of 2018. It went into effect actually earlier this month. And it is targeted at for-profit businesses that meet at least one of the three thresholds you see on the screen. Again, you only need to meet one. So 25 million or more in annual revenue, acquiring information on 50,000 California consumers, households, or devices, or deriving 50% or more of your revenue from the sale of personal information. So if your business, your organization crosses any one of these three thresholds, you are then a covered business under the California CCPA and are obligated to comply beginning with the first California residence information you collect. So don't look at that 50,000 and think, oh, well, as long as I'm under 50,000, I'm okay. You have just one California residence information collected. You have a need to comply for that one resident. A lot of times with the CCPA, there are some misconceptions. So let's kind of get those out of the way first and talk a little bit about what the CCPA is not. CCPA doesn't say anything about what you can and can't collect. So you'll see some interpretations or articles or maybe discussions in the industry where people have made a decision maybe not to collect something because of CCPA. Well, that can certainly happen. Always, we should be asking ourselves a question about the value of a piece of information we collect balanced against the risk of maintaining that data. And in some cases, laws like CCPA cause us as businesses to revisit the information we're collecting and reevaluate. Right, so we may say, okay, well, we're not going to collect that anymore. Really, it's because we're not getting much use out of it, and we don't want to have to disclose we have it, for example, or handle it in a certain way. That's fine, but the law doesn't require us to say stop collecting email address or something of that nature. It has nothing in there about what you can and can't collect. It also doesn't say much, with only a couple of exceptions, about what you can't do with the data. So along the same lines, you're free to continue your existing campaigns as they are, most likely. There's no, hey, you can't use that information for a certain type of outreach effort, or you can't do this or that in direct mail or email or whatever. What it does say is that if you're a business that collects data on California consumers, then you need to provide those consumers with some new rights. All right, so those new rights, and we'll go through them in a little more detail in the call, are to essentially allow the consumer to see the data that you have on them, to tell them how you may have disclosed that information to others, how you may have sold that information to others, and sell is defined a bit broadly. We'll get into that a little bit later. And finally, allow consumers to opt out of selling that information, and if they request it, delete any non-essential data that you may have about them. And again, all of these things have their exceptions. You know, the law is I think 16 pages, so there's a lot to it. You know, I'm not here today to offer you legal advice on exceptions and things, although I'll certainly go through them. So you'll want to examine your own business processes and determine where things are essential, for example, or non-essential, and where they meet the requirement to, for example, be deleted. The law went into effect, as I mentioned, on January 1st. I should point out that the California Attorney General will not bring any actions against businesses for non-compliance prior to July 1st of this year. So at least that's where it stands now. They could always, you know, move that back a bit, I guess, because the AG is still working on the guidelines to supplement the law. But as it stands now, no civil action would be taken prior to July 1st. That doesn't mean that right now is a free period where you don't have to comply, right? There's still the risk, for example, of bad press for non-compliance, consumers complaining in a public way, right? That brings you unwanted attention. So compliance is important immediately, but the AG, the state, will not bring enforcement actions until beginning of July. There is a 12-month look-back period, and what that means is if a consumer comes to you and asks to know what you know about them and what you've done with their data, the disclosure of what you've done with their data needs to go back 12 months and no more than that. It also, in the law, allows you to only look back what your normal business processes would do. So that's an important consideration, right? In other words, you do not need to lengthen. Let's say you keep a list that you have executed against only for 90 days. If that is your normal course of business, then your report may only go back 90 days. You're not required to increase it to 12 months in order to comply with the law. That makes sense because by increasing retention, you would actually increase the risk to consumers, right? So part of what privacy laws are concerned with is that consumers are unaware of where their data is, how long it sits around, and the last thing the law wants to do is basically force you to keep it even longer than you otherwise would have just for the purpose of complying. So know that if you go back more than 12 months is what you must report. If you go back something less than that, then the full scope of what you're going back should be considered for the report. You have 45 days to validate a consumer request. That really just means that validate the identity of a consumer. As you might imagine, when a person comes to you and asks, hey, what do you know about me? The first question we should ask is, who are you, right? And how can you prove who you are? Because the last thing we want to do is use a facility like this to create an additional vector for fraud. So whether it just be something like a nosy neighbor, right, who wants to know something about what their neighbor's up to, or whether it be a fraudster out there who's looking for more data to fill in a profile and go somewhere else to leverage it, say to open a loan or something in someone else's name, we want to be sure that doesn't happen. We're not part of that. And so strong validation of a consumer request can take many forms. There are companies who are doing manual verification for that. So scan a copy of your utility bill and your driver's license and mail that in. You know, take a picture of yourself with the driver's license, all that kind of stuff, and they're doing it manually. There are others that are doing it electronically with third-party services. So Axiom, for example, has a verify and authenticate service where we can ask out of wallet questions and score the person's identity. However you do that, you have 45 days to complete that validation and get back to the consumer with a response to their request. If you should have some kind of hiccup there, you can notify the customer during the initial 45 days that you are going to need an additional 45 days. So you have up to 90 total, where as long as within the first 45 you notify the consumer that you're having a problem. Obviously, the first 45 is what you really want to respond in. That second 45 days should be an exception that truly is an issue rather than your normal processing. You're not required to provide more than 2 reports in any 12-month period. That is free. I'm not aware right off of many who are electing to charge for additional reports. There are some who are refusing to produce additional reports until it's time again. The reason not many are electing to charge for additional reports is twofold. Number one, it's just a practical thing, setting up the additional, fee collection and whatnot for that, for the very limited number of additional reports that would be requested, doesn't pay out, right? So just setting up a process to collect payment, process payments and everything for what's likely to be a handful of extra requests a year doesn't make sense. It's actually more it's just cheaper. It's more efficient simply to give those extra reports away to the few people who will ask for them. But you do have the ability to limit to 2 free and then charge or refuse after that. If you elect to charge or refuse, be sure that you are very good on the identity. Certainly don't want to accidentally, get confused on something like a generation, right? Chuck Price Sr., Chuck Price Jr., and refuse somebody a report you've not provided it to. Businesses are responsible for their own readiness and compliance. You might wonder, well, why is that stated? Because it would seem obvious, but we're all in a very connected data environment. And what I mean by that is that data moves, right? We all on this call, I think, are in an industry where, we move data from a client to us, and then an offer goes out through us, maybe, or through our services. Data made a circuit, and who owns the data at each step in the process is important to understanding who's responsible for compliance at that point. So businesses that collect and own data are responsible for their own readiness and compliance, even if they're using third-party service providers to handle that information, to enhance that information, to execute based upon that information. And for those of you on the call who might be thinking, well, I'm a service provider pretty much exclusively, right? So I don't collect and use my own data. then you just need to be ready for the questions your clients may bring to you about, well, what are you doing for their compliance, right? And your answer might need to help walk them through the understanding that as a service provider, you're there to fulfill their needs. It's their data, and therefore, you will follow their compliance directives for which you may need to develop or implement a solution that changes pricing, but that they are ultimately responsible for scoping and speccing the compliance that they need from you. There are many, as I said a bit ago, exemptions and exceptions here and there in the law, not something we can get into all of them. I'll point out a couple of our bigger ones here in a bit, but we can't get into them all. So if you have questions, refer back to the CCPA itself, as well as the guidelines provided by the California Attorney General, because, again, there are a number of exceptions. At a high level, the exceptions that are maybe most relevant to you will depend on your industry. If you tend to work with clients in banking or insurance or brokerage, they are governed by certain federal law. And if you're familiar with acronyms like FCRA or GLBA, those are applicable in the financial space. And so where data falls under those federal laws, it is exempt from CCPA. A state legislation basically didn't want to find itself in conflict with a federal legislation, and so they simply exempted themselves where they felt that certain federal laws were more strict or already had a handle on privacy. If you happen to do work in the medical field, then laws like HIPAA also are the same concept, right? They're a federal law, and therefore CCPA sets itself aside. So do look at the law itself, and if you need it, get inside or outside counsel to kind of help you define, based upon the types of services and industry you serve, where those exemptions and exceptions might be. The critical data flows and workflows for CCPA readiness are listed here on the screen in front of you. So this is what most businesses that collect information about California residents would go through in order to build their own compliance. They would first identify, inventory, and categorize what data they have. Right? You'd be surprised how fragmented consumer information is across many businesses. And that information then needs to be kind of brought together into a single view, at least on a spreadsheet, right? So that someone can say, okay, here's all the data we know about a person, say Chuck, right? And from all of our systems. Once that's identified and categorized, then you have a starting point for, all right, what do we do with this data that we have? And that's the second step, right? Where does this data go? What business processes use the data? And where along those processes is some of that data being disclosed or sold to third parties? And sold is defined fairly broadly by CCPA. Broadly enough to say not just data exchange for monetary value, but any other valuable consideration. And that's pretty open, right? It gives many attorneys a bit of a headache on, well, now I've got to interpret what other valuable consideration means, and I might do it differently than other counsel. And no doubt, in the meetings we've heard, we see clients making decisions that are slightly different in this area. But that is, your and your clients' ultimate business risk to decide. Where you have a business process that you define as selling, it's important to note that because you need to disclose that separately to the consumer. And also, and in two steps, we're going to talk about opt-out, and it would apply there. Identifying those third parties and categorizing them is important because the law requires that you disclose the third parties to whom you have shared data, but only to do it at the category level. In other words, it's not necessary for a business to say that I have hired Acme Email Solutions in order to send my email and I gave them your information. The category label can be used instead of the actual business name. And again, unfortunately, the law doesn't prescribe categories. So what categories a business chooses to use for its third parties, it may. And therefore, it may just call that email services. It may call that mail services more generally. It may call it direct mail service providers or whatever it wishes to. But you need to disclose by category any third parties who receive data. Getting to the processing stage, which is where a lot of work needs to be done in terms of code development, right? Because processing an opt-out and delete requires new functionality for most systems. First of all, opt-out, again, opt-out is something we're all familiar with, the term opt-out, right? It means, to us, before CCPA, it means asking to be off the list, right? Clicking unsubscribe, I've opted out. Well, California reused that term, opt-out, but unfortunately it means something different. Here in CCPA, opt-out means I don't want you to sell my information. I am opting out from the resale of my personal information. In order to comply with that, you needed to already have identified the processes that we're selling, right? We talked about that a couple of steps ago. And now you need to be able to create suppressions to handle the request for consumers. So if Chuck comes to you and says, hey, you know, I live in Los Angeles and I want you to stop selling my information, it doesn't mean you have to get rid of my information yourself, but any processes that you've identified as selling the data must be suppressed for me. So you need that functionality to be built. Delete means I'm asking you to forget me, right? I'm asking you to remove the information you have about me from your systems. Delete has the most exceptions of any of the new rights granted to California consumers. So as you might imagine, oh, that could interfere with my business, right, in ways that hurt the consumer. So for example, a consumer has a subscription and they receive a publication for that prescription or subscription monthly. And then during that time, they ask to be deleted. Well, if we complied, we would no longer be able to deliver the consumer what they've paid for, the service they have subscribed for. And so that is one of the exceptions, right? We need that data in order to continue to provide the service that the customer is paying for. There are many others. So again, this is an area where you probably want counsel, and the counsel will need to know, based upon your business processes, what is this process doing? They will make a decision with you as to whether or not that process is a critical process or an optional process. And most likely, critical processes would be exempt from delete, and optional processes would be subject to delete. But that is an individual decision based upon your business, the industry of the clients that you may be serving, and just discussions with your counsel. Finally, you need a facility that a consumer can come to you on, usually a website or maybe a telephone number, and make their request, right? So these new rights being granted to California residents are going to be exercised primarily on the web and over the phone. And so you need processes that will validate that consumer's identity, process a consumer report, and ultimately feed, if it's requested, the opt-out and delete processes. So those are the critical data workflows. They kind of go in that basic order, and you can tell as you go through them that a lot of the same resources. For example, IT is a strong resource in this. Marketing and other processes that use data are critical to a number of these steps, and legal compliance functions. Let's talk a little bit about the different kinds of data that you may have in your systems and how they impact the need for compliance. So first on the left, we have personally identifiable information, PII. That is information like name, address, telephone number, IP address, right? That can be used to specifically, they themselves, identify a person, a household, or their device as indicated under the CCPA. That's obviously something that needs compliance. It is by its own nature identifiable, and therefore it is something that must be reported. Anonymous data all the way to the right is exactly the opposite. It's data that isn't tied to someone. And this is an important question to ask yourselves, cannot be tied back to an individual, should you even want to, right? I'll give you some examples. In an analytic environment, you may have summarized data that lets us look at the purchases that people have made by large geographies, say zip codes. That information doesn't have the name and address and phone number or email address of the people who made those purchases. It simply aggregates it by zip code. And therefore, while that information is valuable for analytics, that information is not leverageable back to an individual. It's anonymous, and therefore it is not subject to CCPA. So no information has to be deleted from that database, for example, should a consumer request it, because you actually have no way to comply or match into that database, right? That's the important litmus test there for, is the data anonymous? If there is a way to re-identify the data, then that's that pseudo-anonymous data there in the middle, right? It could be re-identified if you need it to be. There are reasons to hold data in this state. For example, sometimes exchanging data with third parties, this is done, where a special key replaces PII on the file, so the third party cannot see the PII. But when the party sends data back, then it could be re-identified. There's a need for that, again, at some places. It's not inherently bad to do pseudo-anonymous data, but where data is in a pseudo-anonymous state, it is exempt, but where you re-identify it, obviously, it is not exempt. It needs to have compliance around it. So be careful with pseudonymous data, because that is an area where it could be easy to miss the relinking of data, right? So if we had an analytics environment where the data was pseudonymous, there was an ID there that didn't mean anything, but that ID could be used to link back to an operational platform to tell us who it was, right? That's an easy thing for compliance to be unaware of, right? They know the system's there, they know it's exempt, but then an analyst gets asked a question, say by a product person or a marketing team, and they don't have the answer, but they know they can go get it if they just match back to an operational platform, and they just re-identified data and compliance wasn't even aware it happened, right? So those those really bring about a need for tight control. With CCPA, it's important to know your partner's practices. So business verification, what data they're collecting, how they are being transparent, how they're providing notice and control over the data to consumers, knowing all that is important, as well as it's important perhaps more so for those of you on this call to clearly be defined in your agreements as a service provider. So where you are providing a service or where you are using another third party as a service provider, it is important to have language in your agreement that clearly identifies that. Why? Well, service providers have a obligation to the actual covered business, right? It is not their data. So should, for example, Acme Corporation send data to one of you in order to send out an offer on their behalf, you're fulfilling a service on behalf of that client. That data is not yours, and therefore you have not collected it. That's important because then your obligations are only to your client, not to the CCPA, as that is not your data. Where it's unclear, right? There's always the risk of interpretation that you had collected that data yourself, and therefore you have compliance obligations on that data. Let's talk a little bit about opt-out and delete, because they are such big new pieces to the legislation. The opt-out is important because, and remember that opt-out, by the way, is the opting out from the sale of data. It has nothing to do with do not contact me. It is only opting out of this, the resale of my information. An important point to make is that third parties with whom the data was already shared must be notified. So if you are maintaining a file for a client and that client has processes that sell data, the data is sitting on your systems, even if you're not directly involved in the sale of data, you may expect to receive a notification from your client to delete certain records periodically for people who have asked to opt out. On the delete side, pretty clear in terms of, you know, what needs to be deleted, subject to all of those exceptions we talked about, and a few of them are listed here in this paragraph for things like I mentioned earlier, completing a transaction, if you need certain data to detect security incidents, that is to protect the consumer. So if you have data for like, you know, your favorite who is your favorite teacher, some of those security questions, right? You don't have to go delete all that data. Those are necessary to protect the consumer. But the gray area is what I want to talk about here. The law doesn't really say anything about what you need to do post-delete. So you may have kind of a business process set up to do one of two things. Number one, process the delete and be done. And that is, any new data that comes in is new data after you've already complied, and therefore you will keep it. Less regulated industries tend to lean a little bit toward that approach. It's cheaper, right? Because you've executed your delete, you don't need to create any kind of suppressions. If new data comes in, and if they request to be deleted again, you'll do it. So that is one approach. More regulated industries, like I mentioned earlier, finance and healthcare, tend to take a more conservative approach and say that if a consumer requests us to delete their data, we're going to delete it, and then we're going to take an additional step to add a suppression to be sure that we don't recollect their data again in the future. Again, that's, you know, an enhancement, I think, to what is in the requirement of the law, but is in the best interest of both the business and the consumer. Well, why is it in both their interests? Obviously, it's in the interest of the consumer because if they request a delete, they probably don't want you to reacquire more data about them. That makes sense. But on the business side, it's beneficial for us too, because a consumer who has requested information be deleted, right, I don't want you to have my data, please delete it, is probably not a likely responder to future marketing offers from us, being reminded each time they receive one that we still have data about them after they've asked us to delete it. So many businesses are creating suppressions in order to best fit with what they perceive to be the customer's true request. Please delete my information and don't collect any more. All right, but that's a gray area. So, you know, that's a decision between you and your legal team. I talked about the workflow and just focusing on that last part there. Validating the consumer's identity is a big challenge. Make sure that you understand kind of what you think your needs will be and how, therefore, you should set that up. I can tell you that most of our clients, and you know, Axiom has clients ranging from mainly mid-sized to large institutions, are seeing 20 roughly requests come in a week. So it's not right now a significant volume. So going and building, you know, the fanciest of web portals to handle all of this is great if you have the budget for it, but you very likely could handle this with a manual process at today's expected volumes. It's possible that this volume increases over time. One thing we've seen in the European Union in response to GDPR is services springing up that submit requests on behalf of consumers. And we should expect something similar in the US. The California law does allow agents to make requests on behalf of consumers. And therefore, you kind of have an additional need then to verify the agent actually is acting on behalf of a consumer and process the request. So where is this going? Well, I don't know. I don't talk to them. But for example, let's use LifeLock as an example. LifeLock provides a service to consumers that they can do themselves, right? It reaches out to a credit bureau and issues things like a credit freeze on the consumer's behalf. The consumer could have done that, but the value to the consumer was, hey, I'll pay a small fee and you take care of all the paperwork for me, right? You know, you can contact multiple bureaus. I don't want that headache. Well, the same type of thing could be coming here, where the LifeLocks of the world expand or other services spring up that offer to say, you know, I'll contact all the largest service providers and service businesses and product businesses, and I'll just submit a request to thousands on your behalf. If that happens, then the number of requests may increase. All right, so a few key things here are, just to review, right, are the value of the consumer is important. You can limit to 2 in a 12-month period. The portability or delivered in the mail, I should talk a little bit about. So when a consumer asks for what information you have, almost everybody I'm aware of is doing that in the mail as one option. So a report can be printed and mailed, or is doing it online, right? You can receive an electronic copy of the report, so that's the portable version of it. There is not a prescribed format for either. So you see a lot of variation from one company to the next as to how they've chosen to implement this. In terms of portability, the law does say it needs to be movable to a third party should the consumer wish to do so. So that kind of suggests that something like a JSON would be needed, or an XML structure to allow a customer to export their data to some electronic format that they could then re-import it somewhere else. But those technologies are not specifically named in the legislation. It just creates the need for portability. So how you interpret portability will affect your implementation. You need notice of the right to opt out on your website. That is specifically required. If you go around the web, you might spend the next day, when you do, just scrolling to the bottom and seeing if you see a link that says, do not sell my personal information. That is the exact text that the CCPA requires to be on a website. So you will see those exact words and a link that takes you to whatever that company's experience is for opting out, but that notice is required. Response in 45 days, we talked about. You can have a second 45 days for those rare exceptions when they occur, provided you notify the consumer within the first 45 days. And then finally, access to these rights needs to be provided by the web, 800 number, and or email address. There have been a number of changes since CCPA has passed, right? CCPA is an interesting legislation because it was kind of forced by a ballot issue. So Alistair McTaggart in California put a ballot issue out to force the issue of privacy. For the legislature, a ballot issue is not ideal because it's more difficult to change in the future. And so they made a deal, right? The California legislature would pass CCPA if McTaggart would take down his ballot initiative, and they came to an agreement. Well, that had to be done so quickly that CCPA has already been amended a number of times. As a matter of fact, all the amendments you see in front of you were passed prior to the law even going into effect. So for the most part, the amendments didn't change too much significantly. They clarified things more than anything, but there are a few things. So for example, employee information is deferred for a year. There's also a list of things that the California Attorney General has proposed, text of regulations associated with the bill. So these are just as important as the CCPA itself. So I think I mentioned before that the original law was like 16 pages. The AG published 24 pages of regulations around the law. And the first thing those regulations do is set up the same penalties for a CCPA violation and for a proposed regulation violation. So these are important. These are as important as the law. And in many areas, he further clarified things like the use of third-party services to validate, the need for the hurdle to identify a consumer, match the level of data you're about to provide. So while they didn't change the law significantly, they provided important considerations as you look at your compliance. So don't look just at the CCPA AG's proposed text of regulations, and you will find very good explanations in there of what his office will consider compliance. Some things to think about, right? So one, determine if you're a business collecting or selling consumers' information. You have to look at your processes in order to be able to do that. Review transparency and notice obligations. The CCPA doesn't say this, but be aware that anything you're committing to in writing in front of the consumer should be taken at the same level as a regulation like the CCPA. If you're making promises about how you'll use data, be sure you're not using it differently than you've promised. So be transparent. Make sure your notice obligations are met and up to date. And sometimes we have to stay on top of those as technology changes, as ways to communicate change, as the different uses of information come about. It is important to be sure that we keep our notices up to date. Be able to respond to consumer requests. Know the rights of erasure or deletion, the right to opt out or object to a sale, and non-discrimination. I didn't mention non-discrimination because I don't think many of you on the call probably determine the offers themselves, but what non-discrimination says is if someone exercises their rights, they will not lose a service level or be otherwise given poorer offers than they would. So it's unfair to penalize a customer just because they've said, I don't want you to resell my information, right? To say, okay, well, that means that you're going to pay more. Unless you can connect the sale of information directly monetarily to the customer in a way that lets you exempt that. And that is one of the things that counsel will have to help you figure out as you look at your processes. And finally, assess the marketing value of data versus litigation risk. I mentioned this a couple of times, and it's just a core principle, even outside of CCPA. If you're collecting data, know why you're collecting it and what value you're getting from it. If that value is out of balance with the risk associated with it, you have to ask whether you should continue to collect that information. All right, with that, I will open the, or somebody will help me do so, open the floor for questions.
Yeah, right now we have one question here, Chuck. It says, does the CCPA specify how long a mail service provider can retain their customers' data?
No, it does not. So it does not, the CCPA does not require any retention specifically of data. There may be other laws depending on the client's industry that require it. So financial services, for example, depending on if it's a loan, if you're handling credit card offers, you could have years that the customer has to keep it. As a mailer, you may only play a small role in that. But the CCPA does not require a specific retention period. It just says if you are maintaining it, you need to go back 12 months, right? So you can't keep 3 years of data, but only say we've done this in the past month. No, you've got to, if you're keeping more than 12 months, you have to show 12 months. If you're keeping less, you only have to show what you're keeping.
Chuck, I'm sorry. I have a question here. As a service provider who resells your data, do you have to, if a consumer contacts us for their data or requests to remove the data, should you go back to the original source?
Okay, so let me make sure I understand the question right. So I'll kind of give you a scenario. If a business purchases data from a third party, so let's say that Acme Corporation buys enhancement data directly from Axiom, right? So Acme sends us their customer file. We add income data to it for their use and give it back to them. Now Acme has acquired new data about a customer from a third party, Axiom. When that delete request comes into Acme, the scope of the delete is limited to Acme and its service providers, not the original source, Axiom. So it would not affect Axiom's compliance at all. It only affects data that Acme has itself and that service providers may be maintaining on behalf of Acme, right? So that's the limited scope. Now, you may ask, well, what happens if Axiom receives such a request directly? How would that affect Acme, right? Look at it from the other side. And the answer to that is that initially nothing happens. That is, Axiom receives a delete request and we delete that individual or we opt the person out if that was their request. But Acme's already got a copy of that person's data and nothing happens to it, right? It's an Acme and we don't forward a request to delete because they're not a service provider. You're only required to notify your service providers, right? And they are a client in that scenario, not a service provider. And this is why I mentioned earlier, agreements need to clearly identify what processes are under a service provider relationship and which are not, so that it's clear where data is sold and where data is being maintained as a service provider. Now, back to what happens though in the future. Should Acme come back to Axiom again, hey, a month has passed or 3 months have passed and it's time for me to update my files, here's my customer list. At that point, Axiom has removed that person from our data sales who asked us to do so. And so when we append and send the file back to Acme, that person would not have matching data. So that's how the compliance essentially would trickle over to a customer who buys data, is that data would disappear or become unavailable after the point the business that sells it updated their files.
So it's obvious that the trail of ownership here and custody is going to be something that's going to take a little bit of thinking on the part of everyone involved to make sure that whoever has to do what knows their role, I guess.
Absolutely, it's important to have clear, definitions, and that's why I said, take a look at your agreements. Be very careful to expressly define where data is owned by you and where it's not, where it's owned by your client. Because where it's owned by the client and you're acting as a service provider, it's all on the client to comply. And yes, they may need your help, but that's just part of your agreement with them, right? You may need to do some development work or manage suppression files additionally, whatever they need, but you're just helping them with their compliance. Where you yourself own data or have collected it or have shared rights to it, right? Shared rights, by the way, look a little bit like selling to the CCPA. Then you may have both a need to help your clients with their compliance and a need to create your own compliance.
Okay. Two more questions here. By creating suppression files, do you have to report that as well as you are collecting data still?
So that's a good question because it applies mostly with a delete, right? If you delete everything, then how could you possibly continue to comply? And the law foresaw that problem and allows you to keep identifiers necessary in order to continue to comply. So, if I've opted out of selling, then you need to persist something in order to be able to have a memory that I've opted out. So number one, you're allowed to keep it. You do not have to delete it. Number two, in terms of the reporting, which was the question, the law doesn't say anything about whether or not you have to report data so specific, right? But it does say that you have to report anything you can connect to the identity of the person or anything that is itself PII. So the point of view there would be that, yes, you should go ahead and disclose the fact that, hey, if I know you have opted out, right? So that is one of the pieces of data I have about you. Whether they've opted out or not, I'm sorry, go ahead.
No, so yes, you do have to report a suppression file then.
Well, I mean, I wouldn't report the suppression file as like we have you on this suppression file and this name or whatever, but absolutely I would report that, I know your first name is Chuck, your last name is Price, and that I have this telephone number for you, I have this address for you, and I am aware that you have opted out. So that's the piece of information that the suppression file is fulfilling, right? It's the opt-out suppression. The fact that it's on a particular file in a particular table or something like that isn't important to the consumer. Now, you may, you may disclose more if you want to, but I think that kind of thing might be confusing. I would just report that you're aware of the suppression, and therefore you've disclosed that you're keeping that data.
Okay. Another question here: if I buy a list from you on behalf of my customer for one-time use, am I responsible for deleting people that request it?
So another good question. If it is truly one-time use, that is, the file was purchased, it went through and was gone, right? There wasn't any maintenance on the background. It's unusual that a file truly is one-time use and nothing is persisted, because at least from an analytic perspective, they usually want to hold on to something, right? So as long as what they held on to is anonymous now, maybe by some invitation code or something, then no, the file need not be reported or subject to delete or future opt-out because it was one-time use. That is one of the exceptions within the CCPA itself. But use the one-time use exemption carefully, because you really have to examine a process. You may be only seeing a piece of what happened and thinking that it was one-time use, when in reality the process persists data somewhere. And then you've taken an exemption for something that you didn't really deserve.
Okay. The question to clarify something here: does the CCPA apply to data owners outside the state of California, and does it apply only to the consumers who reside in California?
Another good question. So the location of the business is unimportant. So where you're incorporated or where you have physical presence does not matter. What matters is the second part of that question. Was data collected about a resident of California while they were in California? All right, so if you only have retail store locations and you only process online orders for people in Illinois, and a California resident walks into your business and buys something, that's not subject to CCPA. They were present in Illinois at the time that data was collected. Now, they go fly home, right? You turn around and send that file out to Axiom and you enhance it. Well, you've probably collected data about that consumer that needs to be subject to compliance. But I don't know of anyone getting that sticky with it. If it's a California resident, they're usually disclosing, reporting, etc. Because it's easier to just build one process that handles everything than try to say, okay, well, that transaction occurred at with a card swipe at a terminal in Illinois, and therefore that person was not present in California, so I'm going to exclude it. The concept I would still go back to is the consumer deserves notice, transparency, right? And that's the part that would obscure, and control over their data. So, but to answer the question, directly, it's business can be located anywhere. The California resident is protected technically only for information collected while they were in California.
Which, of course, where you got the information then becomes a point of contention if anybody wants to argue about it.
That's right.
Well, I think it's safe to say, Chuck, as we're almost done with our hour here, that this is something which, like an onion, reveals more as you peel it open. This is getting more and more complicated. I guess, as the regulations are fleshed out and as, you know, questions like what if and in different scenarios are provided. So I think this is something about which we'll be continuing to hear more, and which probably will generate yet more webinars to go through the details as time becomes necessary. I will guarantee you that I will get back to you about more information, so anticipate some emails. But I want to, as I said, as we're getting close to our hour here, I want to make sure that I thank you and everybody else in the Axiom team who was very thoughtful and helpful in getting us put together today, because this is something which, as I said, all of our subscribers have to be aware of and about which they'll continue to hear more information in the future. So thank you, Chuck, and thank you to everybody back at Axiom for doing this for us. I want to thank everybody who called in today. I think you've learned some important information. As I said, we will be getting more out to you as time passes, so this isn't your one last shot. I want to thank Jennifer for helping out on the technical side, and of course to everybody on the Mailers Hub team here for always supporting all the work that we do. We will have another webinar, as it turns out, tomorrow, a last-minute review of the rates that are taking effect on Sunday, so if anybody wants to sign up for that, you may. And otherwise, we'll have our next scheduled webinar in February, as we do every month, and look forward to having everybody call in then. So again, as we close out the hour, thank you all for calling in today. Thank you, Chuck and the Axiom folks. Thank you, Jennifer. We will talk to you again tomorrow or next February. Meantime, take care. Thanks.